Without personal appearance, Mr. Hastings.
Okay. Good evening. My name's Ken Hastings. I'm with the Mason Springs Conservancy, and Ms. Jones just stole some of my thunder because I really didn't expect anyone to announce the results of the Compliance Board decision because nothing else about the what I refer to as an illegal meeting on the 21st has been done correctly. And that was the basis of my complaint. I made the complaint to the Compliance Board. The Deputy County Attorney rebutted that complaint. The board didn't buy any of what she had to say about the situation. And he sided with me, which wasn't too difficult because I'd already read the materials, I already understood, and I've watched for years as no one in Charles County ever closes a meeting and opens it back up correctly. And years ago, I spent $300 I really didn't have to spend to go to a seminar presented by the Maryland Attorney General's office at the time, and it was all about the Open Meetings Act and the Public Information Act. And I did this because I recognized that if part of my life was going to be as an advocate, I had to make sure I understood what the rules were. And I've been disillusioned for 2 decades now to see how people have done everything they can to get around the Public Information Act and the Open Meetings Act. Open Meetings is a particular hard spot because the law says that the exclusions are discretionary. There's nothing in the Open Meetings Act that says you have to close a meeting. They're all done with may. You may close a meeting under these circumstances. You may close a meeting for this, that, and the other thing. None of those are mandated. And in the case of the one on the 21st, and I didn't take this up with the Compliance Board because it wasn't germane at the time, but as I researched some more in answering the rebuttal from the Deputy County Attorney, I recognized that the personnel exclusion only applies to individuals. It doesn't apply to classes of individuals. And that evening, you were talking about a class of individuals, 3 people who had received a recusal letter accusing them of having conflicts of interest. It wasn't necessary to make this a personal thing. Their names didn't have to be used in order to give generic advice, legal advice, to people similarly impacted by what I've reviewed as a ridiculous letter. So it's not just a matter of following the letter of what it says you have to do if you decide to close a meeting. It's a matter of deciding whether or not you can actually do your job and get the things done that you need done without closing the meeting. It certainly casts a shadow over the whole process when you go into closed session and vote to decide not to take further input on the comprehensive plan. Why couldn't that have been done in open session? And it just blew my mind that was in the minutes, not of the closed session, because there were no minutes of the closed session. Another violation that I was happy to point out. And I didn't think I would get closed session minutes anyway. I figured if I got them to be so heavily redacted, they'd be useless to me, just be one page with a bunch of black lines to it, and I couldn't tell anything. But the Associate County Attorney who answered my Public Information Act request before I went to the Compliance Board, to make sure I had all my ducks in a row, I asked for all the documents that were supposed to be produced, and he very candidly admitted that they didn't do any of them, none of those documents. There were no closed session minutes. The Compliance Board needs closed session minutes in case somebody complains that something was done in closed session that shouldn't have been done. They can get the minutes, and they're supposed to be able to do that. But that didn't happen. I noticed one other thing here in the process of doing my PIA request. The Associate County Attorney, I think his name is Storch, I don't know if I have that right or not, he commented that he thought that all of the planning commissioners had taken the course, the mandated course on open meetings. In the document that Ms. Theobald's produced, she said that the chair and Ms. Pickerel had been designated as the people who were supposed to take the course. But tonight, I think I heard that you're all going to take the Open Meetings Act course. And that's a good thing for everybody to be up to score on that. But it just seems like the county really didn't have this as a priority. if they didn't know who was even supposed to take the course, didn't know who had taken the course. They're supposed to keep a list, but they didn't have a list. And the guy that answered my PIA request candidly admitted, they didn't have a list, didn't have a clue, didn't know if anyone had ever taken the course or not. But he thought that all the planning commissioners had taken it. Well, my guess is, and I'm just guessing here because I don't know, no one's ever taken the course. So I'm interested in seeing how this plays out.
I think, if I may say, Mr. Hastings, and correct me if I'm wrong, Ms. Theobald, all of what he's speaking of, his complaint are on board docs, are they?
I don't know that it's on board docs. Excuse me. I don't know that it's on board docs, but I believe it is a matter of something that is available online through the through the Attorney General's office website.
Through the Attorney General? Mm-hmm. Yes, I was going to say that all of what you're speaking of, there is an opinion of the Open Meetings Act from the Open Meetings Compliance Board. So what you are addressing is in writing and possibly available for.
Which I couldn't hear this interchange that happened.
No, I'm saying what you're speaking of is available. She said she thinks on the Attorney General's website. Your comments in terms of the response. They responded to you July 20th, 2016.
Yes.
They responded to, and the county got a copy of the response, and it is online, I believe, according to what she's saying.
And that's fine. My question was, who is actually going to take the course? And I guess the follow-on question that is, who has actually taken the course? In all of Charles County, I would be interested in knowing who has ever taken that course. Now, to be fair, it's only been since 2014 when the General Assembly required that. Maybe it was 15, but it's been in the last few years. So maybe they haven't had a chance. I think part of Ms. Theobald's comment back to the board was that, well, there have been a lot of turnover and whatnot, and maybe people have been lax and so forth. But the truth is, the two people that have been designated, according to her document, Commissioner Bowling, Chairman Bowling, he'd been on the board as a chairman for 2 years. And I don't know when Ms. Pickle started being the clerk for the Planning Commission, but forever. Yeah, I went back and I got back to 2008, I think, and I could still see your name as the author of minutes for the Planning Commission. So the argument that, well, geez, there's been a big turnover, well, that didn't really mesh. And I think the board recognized that. They did give kudos to Charles
Can you
County.
Summarize your comments, please, so we can move on?
I didn't know there was a
we try to keep it under a few minutes.
Is there an official limit of some kind, or what's going on here, Steve?
We try to keep it to 3 minutes for public comments, so please summarize so we can move on in our meeting.
It'd probably be a good idea to post that. Yeah. Okay, thank you.
Thank you, Mr. Hastings.
We have one more